Joining us now to recap today's hearing on Capitol Hill is Keisha Russell, counsel at the First Liberty Institute, where she concentrates on religious liberty matters. Keisha, I'm really glad to have you on the program tonight because this is day 3, but day 2 of questioning. And yesterday, we did see, I would say, a more amicable hearing than the one that we've seen just the past one with Justice Brett Kavanaugh. So I want to ask you, from what you've seen today, what were your major takeaways?
Well, we definitely saw Judge Barrett continue her theme of being very relatable, I think, to the American people, and definitely letting them know, sending them a message what her judicial interpretation is, what her goal is on the court, and that is just to interpret the law as it is written. I think she made it very clear that she has no agenda, and even facing the questions from the Democrats, peppering her about questions about the ACA and her intentions there, and she continued to say, you know, I will not answer those kinds of policy questions, and letting people know that, look, my job is to apply the facts of every case to the law, and nothing more. And I think she did a really good job of communicating that today.
And Keisha, I noticed yesterday that a lot of the conversation was taking what Antonin Scalia said on certain issues and then applying it to Judge Barrett and how she would decide on those same issues. They did it with the issue of abortion. They did it on the issue of the Affordable Care Act as well. And I noticed today there was a little bit more of a defense, not only from Senate Republicans, but from the nominee herself. And she says herself that she is an originalist and a textualist. So I want to know a little bit more about this because that seems like what a judge should do. Read the words of the law and then apply it. What is the other side of this spectrum that does not necessarily agree with that philosophy?
Right. So the other side is what you would call loose constructionism, or what's called sometimes referred to as a living constitution. That means the meaning of the Constitution evolves over time and changes with the culture. The problem with that philosophy is that what you'll have is a Constitution that really doesn't have much meaning as time goes on, because depending upon who is interpreting it, they will interpret it the way they want it to be interpreted. And so you'll have some people whose rights are now in jeopardy just because their beliefs are unpopular during that cultural time. The only thing that saves people with beliefs that are unpopular is the Constitution in its original meaning and its original structure. We don't want judges deciding what the law should be from the bench.
And of course, that is usually accompanied with more liberal justices. That's something that, for example, many Democrats will be on board with, whereas Republicans are traditionally more on board with the conservative approach, which would be originalism to some degree. But
That's right.
when we talk about this as well, does that suggest then that perhaps we already know what type of justice Judge Amy Coney Barret would be on the Supreme Court? The fact that we know what her philosophy is, we have extensive writings from her as a professor, not necessarily a judge, although she has been on the bench for 2 to 3 years now at this point. But do we have a good idea of what kind of justice she will be?
I think we have a good idea, at least, of her philosophy in terms of her judicial interpretation, right? We know she's an originalist. We know the way she views the Constitution. We know the way she views her job as a justice. What we don't know is how she's going to rule on a particular case. And I think she made it clear that she can't make those determinations. She shouldn't make those determinations. And because each fact, all the facts of cases are different. Each case is different. And she'll have to make a determination based on the case that's in front of her at that time.
And of course, it looks like she is going to be on the Supreme Court. I mean, barring any major bombshell between now and the ultimate vote. So I don't want to get ahead of myself. I've said this before, but for now, it looks like she is going to be on the high court, which would give conservatives a 6-3 majority. I know a lot of people would say, well, Justice John Roberts isn't always a reliable conservative vote, but nonetheless, he is a conservative on the high bench. So I want to ask you, what does that 6-3 majority mean for the average American? Will it really change their lives as much as perhaps Democrats are threatening?
Well, we haven't had that kind of reliable majority since 1934, and so most Americans have grown up in a country where the majority of the justices did not share this particular judicial philosophy. And so I don't think it's going to change Americans' lives in terms of any policy decisions. That's stuff that should come from Congress and the elected congressmen that are elected by the American people. But through, I think, Judge Barrett's philosophy, I think you'll just see her interpreting the Constitution the way it's supposed to be interpreted, and I think you'll see her being able to demonstrate for the American people that she really has no agenda. And I think ultimately the only impact that this will have on the American people is that they'll see, well, this is exactly what the Supreme Court is supposed to be doing.
And Keisha, a big part of the criticisms levied by Democrats is the idea that Roe v. Wade may be overturned with that 6-3 majority. And I think that there are a lot of people, even those who may be pro-choice, for example, that recognize the fact that Roe v. Wade is not necessarily on the best law. Foundationally, there are some concerns and cracks in that decision. We've heard Antonin Scalia say that. We know how Judge Amy Coney Barret feels about the late Antonin Scalia as well. Do you think that that law, or that I should say, that court decision is in jeopardy with that majority?
Well, I think, and you actually heard her, talk about some of this today. One of the things that judges have to do when they're thinking about overturning precedent is looking at reliance and what the American people, how many people are relying on this particular precedent. So I don't think you can assume, particularly just because of her religious beliefs or just because she's conservative, that she's going to be willing to overturn a precedent like that. I think it's definitely going to come down to the facts of the case as they're presented to her at the time and presented to all 9 justices at the time. But I don't think that you can assume at any point in time that just because the majority of the court is conservative, that means Roe v. Wade is in jeopardy.
Right, and I've heard a lot of people say, too, that it probably wouldn't come in the form of a complete reversal of Roe v. Wade, but perhaps allowing more restrictions to be enacted, or perhaps chipping away at type of Casey undue burden type of things taking place across the states. Because even if you did get rid of Roe v. Wade, for example, in that hypothetical situation, there would still be access among the states that would allow it. Am I correct to say that?
And the states would have the authority to enact legislation to reinforce whatever rights they feel need to be there, as would Congress.
Yeah, so I think that's what a lot of people should be looking out for. And I think that's the answer that is really the true answer. But of course, Democrats want to get a little bit more out of this hearing, perhaps for their own campaign ad sound bites, whatever it may be. But we should get a better idea over the coming days of when she will be on the high court. But Keisha Russell, I really appreciate you coming on the program tonight, breaking down today's hearing. Thank you.